This is immigration attorney Misbah Chaudhary from Misbah Chaudhary and Associates, PLLC, immigration law firm. Today is July 20th, 2020, and we are here in front of you to answer your questions, to give you updates about the immigration world, and then briefly discuss the issue in hand today. So I'll start with the recent updates during the last week in the immigration. Briefly I will discuss each of them, and then we will move forward to the discussion, to the topic which we will be discussing today, which is labor certification. So we will briefly talk about it, and then we will answer the questions what we have received. Again, to start with, as always, kindly see the scrolling screen in front of me, and you will see that there is information about our website, about the telephone number that we have, Instagram, our Skype account. Then we are on LinkedIn and we are on Twitter, so you can contact us there. And when you go to our Facebook page, you can just like the page, and you will start getting all the information that we post there as we get that new information, the most recent one on immigration, and you will, to get you informed, to keep you informed about the things what is happening and which is directly linked and related to all the immigrants who are living in the United States or who are planning to come and live in the United States. So to start with, I will one by one go through it. So ICE has rescinded its rule requiring international students to take in-person classes this fall. It was a big issue during the last 2 weeks, which has been resolved, and I have also put in a live presentation on that as well the moment we received that news. So it's an update from the last week. Detained immigrants must decide whether to separate their families today. So what they are saying is that you need to decide whether to keep their children in detention with them or release them to the outside guardians. So there are minor kids who are in detention, so they have been given the option that they need to decide whether they are going to give them to the guardians or they want to keep those kids along with them. President Trump has said that he will sign an executive order to change immigration laws. This has also been mentioned earlier, that he is saying that he is going to sign something to change the immigration laws, and he has named it merit-based system of immigration. Keep this in mind that immigration is a federal law and can be changed only through legislature. So that we should keep in mind also. Number 3, there is a plan to create a road to citizenship for DACA recipients. Again, if DACA recipient, if it's an amnesty, if it's not an amnesty, that needs to go through the legislative process also. A federal appeal court ruled that the administration cannot withhold grants from California sanctuary cities. So it has been mentioned that the grants will be held. So the court says no, this cannot be done. This happened during the last week also. International students have been denied entry to the United States before the rescission of the order which was given earlier. So the students who have stepped out of the US, they were in US on a international student visa, and they left and then they were trying to come back. They have been stopped. Maybe they have been issued the 221G or for a waiting period to see what will happen, what instructions they will be receiving at the Department of State, and will issue the visa accordingly. The US will soon resume visa services at the embassies abroad. So this is the news also. We have our office has shared before, and it is on our Facebook page as well, where they says that US Department of State is saying that they will be starting and resuming the process of the visa issuance at the US embassies and consulates soon. That means they have not given a date. Earlier it was 15th July, but now it's kind of tentative when they are going to open it. Top US companies have asked Trump not to rescind DACA. Now this is a big news also, that the executives from the top companies including Google, Target, General Motors and Apple, they have sent a letter to the administration branch and this executive branch, and they said to leave the DACA program in place because that directly involves their companies and the economy involved along with that. So these are the most recent updates during the last week that we have received, and that has happened in the world of the immigration, and we like to share it with you so you have the most updated information. Further about the questions, again I will mention that if you have any questions, kindly do you come online and ask them. You have the time, half an hour right here on Mondays, that you can come and ask questions about your cases or about the matters involved, your concern. Because if you are going to send us the messages on Messenger, you're going to send us messages on LinkedIn or on Twitter or email, we can miss on those messages. So it is very important, and it's likely for the other people also who are listening that they can get benefit out of it. So kindly, if you have any concerns, any question that you think that comes in your mind and you want to take care of it, so do come online. We are available live here right now, and I can answer your questions. So that is one concern which I want to pinpoint here. We have, though, like every week, I do try to pick up the questions which have been asked at the random mediums and try to answer those. So again, if any of the people who send us the message, but we have not answered those, or we have not addressed those questions here, kindly send those again, or kindly come on Monday live and ask us the questions live, and we will like to answer those questions to you. So we will start with the labor certification today, as our topic of interest is the labor certification. So what is labor certification? Initially, to start with, labor certification is the process which is done by the Department of Labor. It is not done by the Department of Homeland Security. It is not done by the USCIS. It is done by the Department of Labor, which is a separate department. So once the labor certification is approved and certified, then the next process goes on to the DHS, Department of Homeland Security, and the process, second step is started, which is filing the employment-based petition. And if the priority date is current, or the concurrently file the adjustment of status along with it, which is in common language called the green card process. So labor certification is basically, you need a sponsor. If you want to get the immigrant status, there are two ways. Number one, you get it through the family-based, or you get it through the employment sponsorship. So either your sponsor is a family member, qualifying family member, or your sponsor was a US citizen or green card holder, or your sponsor is an employer, a US company. So a US company can sponsor you and start the green card process for you. So the labor certification is the first step in that direction to move forward. And the basic thing, see, in labor certification, it's quite complicated process. We cannot just say that, oh, randomly you can pick an employee and the employer says, okay, I'll start the green card process for this person, or labor certification process, because you need to see if that person qualifies for that position, or the employer has a qualifying position available for that person. And then the employer has to go through the labor recruitment process. He has to go through the steps involved in the recruitment. In the recruitment process, so I was trying to read the question, but I will answer that. And I will address all these questions after having our brief discussion on the labor certification. So what happened is that the recruitment process is a very, very important step in going through the labor certification process. So what happened in the recruitment? The first process starts with the prevailing wages. The employer company applies for the prevailing wages with its state. The state determines and gives for a particular position and for the particular job duties, and they will issue the prevailing wage. They will determine the prevailing wage for that particular position. So once the prevailing wages are determined, then starts the recruitment process, which starts with the job order number. So you get the job order number from the state, and every state, so we have 50 states here, and every state which is the Workforce Commission, who process all that, the job order number and further dealing with it, their process is separate. They process differently. So it's not that the one, if you are getting a job order number from a TWC, Texas Workforce Commission, it will be the same for Louisiana. It will be same for New York. No. It will be same for California. No, you have to follow, the employer has to follow their requirements for getting the job order number and proceeding further with the recruitment process. So once you get it done, there are certain ways, which includes 2 Sunday ads, and as per the other requirements, posting the job order number or putting the ad in the newspaper, or employee referral program is there. You put ads in the magazines also. You put ads in the college recruitment. There's so many ways out of which you have to pick up and complete your recruitment process. So once the recruitment process is complete in an effective manner, you have to put in your ads in certain positions. So it's not that in all the positions, but there is also requirements of different positions, that what kind of recruitment process needs to be involved in this kind of position, or for this kind of qualification or requirement for the employment. So based on that, that recruitment process is complete. We keep notices of all the recruitment process, and then comes the step after the completion of the recruitment process. There is a 30 days leisure period. Leisure period means that you sit down and you still wait if you receive any resume. If you receive the resumes and there are the qualifying resumes, you need to contact them and you need to interview them, and you need to see if the local people are qualifying the resumes, the candidates, they qualify for that position, because if they qualify for that position, the job needs to be offered to them. And if they qualify, they are the one, and they match the requirements, the job requirements, the job duties, the experience, the qualification, the employer needs to offer them the job, and they are picked up for the job. If in case, if for a certain position no resume is received, nothing is received, or if received from the candidates who do not particularly qualify for that position, in that condition they move forward and apply for or offer the job to the person who qualifies for that particular position, and file the perm application for them. So once the perm application is filed, it depends on the DOL processing time, that how much time they take to process that application. Roughly for right now, it's between 4 months to 4.5 months. And once that is processed and complete and certified by the Department of Labor, then we move forward with the employment-based petition with the Department of Homeland Security. Now, in between, sometimes what happens that the employer can receive a random audit, or for some reason, where they are asking for to provide them with the recruitment process, the whole of the package, what has been done along with the recruitment report. Or if there is any kind of question which the Department of Labor wants to ask on the labor certification application, and that needs to be addressed in a timely manner, in the right manner, provide them with all the documentation requested to move forward with the certification of the labor certification process. So I think so briefly we have talked about the labor certification process. If you have any questions, yes, I'm receiving questions. If you have any questions with regards to the labor certification also, you can ask me here, or you can send us, you can ask us later on also, once you watch our video and you have any questions coming on. But it's always preferable to ask me questions here, because I like to address them live, so the other people listening, they can also get benefit out of it. So we have a question. It says, so DOL cause work right? DOL cause work right? So I'm unable to understand that question. So my understanding is that he wants to ask that whether they are working currently. Yes, DOL is working currently, and every process takes time. So even if we are starting with the labor certification process, it goes through so many steps. We get to have them, go through the job duties, job titles, seeing the requirement, everything. Then what puts in on the request for the prevailing wage determination. Then that takes time. Then the recruitment process. So it's a step by step process, and different departments and different offices under DOL works on that. So yeah, it's an ongoing process, and it takes time in processing, going through all that, and the completion of that process. Then Arshia Adil Khan, do you know why US Embassy in Islamabad is not working? CR1 visa processing, we are waiting for interview date, but they are not working on it. What is the reason? So Arshia, as I mentioned earlier also, the US embassies and consulates, they are working, but they are not conducting one-on-one interviews. They are not conducting in-person interviews because of the COVID-19. So now what they are saying, so it kind of creates a backlog, or kind of creates longer time period to process things. Lesser officers are working over there. So what is happening is that if there is no issue, either there can be an issue where they issue you some kind of request for documents. If there is not, and everything is going on in a right manner, then they are saying it, as I have mentioned when I was going through the most recent postings. They are saying that most recently they have mentioned that they are going to open the embassies and consulates for the in-person interviews also, and start conducting in the same manner. So first they gave us the date July 15th, but there is still some wait on that. So they are saying as soon as possible we will notify you guys when they will open it for the interviews, and hopefully everything will go on fine for you. Then I have another question from Bongo. Can someone who lost status from taking a break from school for a year can apply for reinstatement or get a lawyer to regain status? Okay, yes, get a lawyer. It's complicated. Once your reinstatement, there is certain time period that if you lost your F1 status or M status and you are still in United States, and there is a longer period of time period, I don't have the facts in front of me, and I don't know the reason. We will need to go through certain documentation to figure out what is the reason why the status has not been maintained. But it is always favorable to get legal help in processing these kinds of things, because there can be complication. Also, more importantly, when there is a 1 year gap in between. So I think so it's very important. And there are certain other factors involved, which based on which it can be decided that what should be the next line of action on that. Aisha, you have another one. Do you know why US Embassy in Islamabad is not working? So I think so we have already answered this question, Aisha. So I'm hoping that very soon they are going to resume their process as what they are mentioning, and they are going to call you guys in for the interviews. So we have Ramna. Ramna has a question. Do we have to give interview as well once we file adjustment of status through labor certification? Now, very good question. What was happening earlier was that if you file because the labor certification comes through the employer, so it's in simple language we call it employment-based green card process. So before last year, we were always, you apply for it, you apply for employment-based visa, you apply for the adjustment of status, and you receive the green cards. There were no interviews involved in between. But since the last year, what is happening is that Department of Homeland Security has changed that, and they have added in the interviews for the candidates for the employment-based adjustment of status as well. Even if the kids are minor kids involved, myself, we have clients 5 years old, 6 years old kids with them, and the beneficiaries and the dependents and the main candidate, they all go in front of the officers for the adjustment-based interview, and they get the green card issued, or they get the permanent resident card issued. But the thing is that because all of them are supposed to come over there in front of the officer for the interview, because adjustment of status application is filed separately for each candidate, for every beneficiary. So even if there is a spouse, there is a husband who is a candidate of employment-based petition, right? then he has a wife and he has 2 kids. Now when the adjustment of status applications are filed, they are filed for all of them separately. They are their own applicants, all of them, the husband, wife, the 2 kids, even minor kids. So the separate adjustment of status application goes in, and all 4 applicants, as per the new regulations, all 4 candidates will go in front, adjust for the applicants of the adjustment of status will go in front of the officer and will sit for the interview. Now I will like to address some of the questions which I have noted down here, which we have received via email or messenger, and I would like to answer some of these questions. I am on a TN visa status within the USA. I got another job offer. Can I apply for the change of employer within the USA? If yes, can I start work right away? So this is Mr. Salman from Texas. Again, his question is on the TN visa status currently, right now. So he got another job offer. Maybe there is some problem with the job, with the TN with the job he's working on with the current employer, and he's saying that, can I apply for the change of employer within the USA? If yes, can I start work right away? So he has 2 questions. Yes, he can apply for the change of employer within United States, and that we employed through the employment-based petition we filed it with the USCIS. Even if your initial entry is through border, or you entered through border or the port of entry, but over here, if you are in this current situation, say there are travel bans, or the borders are closed to Canada and to Mexico, whose citizens are eligible for TN visa. So if they are here and they want to file for the change of employer, they can file with the Department of Homeland Security. But as the TN visa does not follow the portability rules like the H-1B, so what happens is that the candidate who applies for the change of employer for the TN visa needs to wait within United States, and after filing the petition needs to wait and see if the petition, once the petition gets approved, he is eligible to start working with the new employer. So there is no portability under TN visas, and he cannot just upon filing of the change of employer can start with the job. He has to wait for the approval. Another question is, can I apply for my spouse through consulate? That is Eric from California. Can apply for my spouse through consulate? Oh, I think so. My understanding is that the question, Eric is trying to question that if he wants, he is a US citizen, and if he wants to apply a petition that is the family-based immigration status or family-based petition through consulate. Under certain circumstances, maybe in extreme circumstances, consulate allows you, but the I-130 petition is always petitioned and filed with the Department of Homeland Security, and upon the approval of the Department of Homeland Security, the I-130, if the spouse is not in US, they go through the consulate process, which we call NVC process, and go through the DOS process, which is the interview through the embassies or consulates, and get the visa and enter United States. So this is the process regularly which is followed. There are certain extreme conditions under which some options can be availed, or there can be some privileges given, but this is the regular process what I'm providing to you the information about. Is there any minimum or maximum amount invest to process E2 visa petition? This is Shazia from New York, and again the question is there any minimum or maximum amount invest to process E2 investment visa petition? No, Shazia, there is no minimum or maximum amount to invest to do the E2 visa. It's not EB-5. EB-5 is also investment visa, on which the previous amount for years and years were $500,000 and $1 million, but now it has been raised to $900,000 to $1.8 million. But EB-5 is a totally different category, which gives you an amount. This is the minimum amount you can invest to process your EB-5 investment visa thing. This is E2 is a separate visa. E2 is under certain countries are provided this option, and number 2 is that there is no minimum or max. There is a substantial amount which is the criteria to see what kind of business is that, what kind of investment is that, what kind of investment or money is involved in setting up that business. It's an acquired business or it's a new set of business. So depending on all that, it depends that what kind of amount is reasonable for the investment to process the E2 visa. But there is no minimum or there is no maximum. I have heard this before also, that some attorneys or some law firms say, oh, you have to come up with 100,000 or 100,000 or more than that to process the E2, otherwise your E2 won't be processed. In our law firm, we have processed E2s for years and years and years, and we have processed from starting from amount, say maybe once we did with 27,000, one investment was 35,000, or we have done also for like 200,000. So max or minimum, it all depends. It should be substantial amount, more than 50% of the cost of the business. All of those requirements needs to be in mind. What kind of investment, how much money is needed in that kind of business. So many factors are kept into mind before processing the E2. There's another question. So what steps would someone who was F1 status a year ago needs to go through to attend the same school again? Would it be to refile it? So it's the reinstatement process, like we have briefly talked about before. We need to go through the reinstatement process, and there is a certain time period under which you have to file for the reinstatement. Again, as I have mentioned, there can be certain conditions involved. If a person who was previously on an F1 and now he's in the remote proceedings, and the judge says, okay, move forward and file the reinstatement. The judge gives the permission that now you can file, even it's been like more than a year or so. So there are certain requirements, there are certain conditions which are involved in moving forward with these kind of petitions. But the process is reinstatement of F1, which needs to be filed with the Department of Homeland Security. There is another question. I have sponsored for my husband, but my income is not enough. I'm a student and I work part-time. What can I do for the affidavit of support? That is Lala from Louisiana. Okay, Lala, I understand you are a U.S. citizen or a green card holder, and you have applied for your spouse, for your husband. Your income, you are saying you are a part-time worker and you are a student also. So your income is not enough as per the poverty guideline to sponsor, to be a sponsor for the affidavit of support. So yes, you can add in a co-sponsor along with you. You can add in a co-sponsor who can be a U.S. citizen or green card holder, preferably U.S. citizen, and they have enough income to show that they qualify as a co-sponsor for and put in the affidavit of support for your husband. There's another question. My son is a U.S. citizen and is 18 years old. Can he petition for me? That is Mr. Riaz from Wisconsin. Okay, Mr. Riaz, if your son is a U.S. citizen, he needs to be 21 years of age to sponsor you. And yes, he can sponsor when he turns 21. So if he's a U.S. citizen, he turns 21, he can sponsor you, he can sponsor your spouse as the parents of a U.S. citizen. Another question, this is the last one on my page, which says, I filed for the K1 visa. My fiance entered USA, but we never got married. So can she apply for any other kind of petition? That's Roger from Texas. So Mr. Roger has applied for the K1 visa, that is the fiance visa. So once he applied for the fiance visa, and this is a very common situation which I have noticed in years and years, that people enter United States, things happen, and the requirement of getting married within 90 days of the entry does not fulfill, and applying for the adjustment of status within United States. So K1 visa is a problematic visa, like C1D visa. There are certain, there's certain kind of visas which are kind of, in my understanding, are complicated, are like their requirements are very tough. So if somebody enter as a K1 on a K1 visa as a fiance of a US citizen, there are certain requirements they need to meet. First, they need to give a statement on affidavit stating that they are going to get married. This is their intention, that once she or he entered United States, within 90 days they are going to get married and apply for their, it will become eligible to apply for the adjustment of status within the United States. Now the requirement, if they don't get married, then there is problem. if they get married to somebody else, if they try to file for something else, then there are issues involved. So K1 is very restrained. K1 visa is very restrained in this matter, that if you enter United States on a K1 visa, you need to fulfill the requirements of the K1 visa by getting married and apply for the adjustment of status. Otherwise, there can be issues involved in that, and in change of status or in doing the adjustment of status, it becomes very tough. So I think so we have answered all the questions, and kindly get all our information on the screen. You can see that our email address is there, our telephone number is there to reach us, our website is there. You can like our page on Facebook, our law firm's page, and you can start getting all the updates. You can send us messages, you can come online. We come online every Monday at 4 o'clock Central Time to answer your questions and to give you updates and to briefly discuss different types of visas and petitions, which can be very helpful for you. Sometimes people don't know what they can do, and that confuses them, and people fall out of status or overstay in United States. So it's very important that you listen to these things and try to follow the information. Thank you very much. Until I see you guys again, if you can call us or you can email us with the questions. Thank you. Bye-bye.